Good afternoon. My name is Ken Winkler, and I'm a shareholder at Berman Fink Van Horn. I'm here today with my colleagues, Bill Piercy, Leah Deering, Rory O'Sullivan, and Lauren Frisch, who I have the pleasure to work with every day at Berman Fink Van Horn. BFV is a law firm committed to helping businesses and business owners succeed. Sharing knowledge about trending legal issues is an important part of what we do and something that we really enjoy. If you have joined us before, you know that we schedule our office hours webinars over lunch to address multiple aspects of operating your business during and after the pandemic. I can share up front that our panel is very excited to share insights about today's topic. What's next? Top considerations to grow your business after the digital pivot. Embracing the digital world is not without risk and consequences. When you are visible on the web, your personal and business reputation is under the microscope. And certainly in a cancel culture like we're living through now, the stakes have never been higher. Our panel today focuses on different practice areas, each of which has dealt with numerous issues arising from the digital pivot. If you have questions during the webinar, please use the Q&A tab to your control panel. Please do not use the chat or raise hand functions. This is a 45-minute webinar, so we will try our best to get through all the questions today. We have a lot of material and questions to cover, so I'm going to hand it over to my law partner, Bill Piercy.
Good afternoon. My name's Bill Piercy, and I focus my practice on helping business owners to get out of bad business relationships so they can go form better ones. Basically, corporate divorce. By the time an entrepreneur comes to me for help, it's common that they're only speaking to their business partner using four-letter words. But what happens when that abrasive dialogue takes place over social media for all the world to see? The messy business breakup between actor and comedian Michael Rappaport and Barstool Sports provides some insights. We thought this case might serve as an interesting springboard from which we could discuss a variety of legal issues. Mr. Rappaport had a podcast with CBS Sports through which he shared his often unfiltered views on sports, politics, and pop culture. Barstool Sports is an online platform focused on sharing similar, often crude and vulgar opinion content about sports and popular cultural and related issues through a variety of podcasts and a website and tweets and similar social media content output forums. Barstool has a rabid fan base, and they call themselves Stoolies. In 2017, Barstool recruited Rappaport away from CBS and to its platform. The honeymoon was short-lived. 8 months in, a Twitter war broke out between Rappaport and Barstool's principals. The insults flew back and forth over social media, becoming ever more caustic and obnoxious. Further escalating matters, Barstool created and began selling on its website a t-shirt depicting Mr. Rappaport as a clown with an exaggerated and unflattering blemish beneath his lip, the implication being that Mr. Rappaport had herpes. For his part, Mr. Rappaport tweeted, quote, "If you call yourself an expletive stoolie for real, you've already lost in life," close quote. Viewing this as a direct insult to its entire fan base, Barstool immediately terminated Rappaport's contract. Rappaport then sued Barstool, inevitably, for breach of contract, fraud, and defamation. Last month, a federal judge in New York issued a 64-page order in that case, complete with quotes and screenshots that could make a sailor blush. If you have the time and you're not easily offended, the order is worth a read. Drop us a line and we will get you a copy of the order if you're interested. What I found most interesting about the court's opinion was its analysis of Mr. Rappaport's defamation claims. Now, what is defamation? It's a purportedly factual statement about someone else made to someone else other still that is both false and harmful. Truth is a defense. Opinions cannot give rise to defamation because they're not facts. Rappaport's defamation claims were based on Barstool repeatedly, graphically, and crudely calling him a racist, a fraud, a hack, a wannabe, and stating that he has herpes and that he stalked and abused an ex-girlfriend. In analyzing these myriad insults, the court found that in calling Mr. Rappaport a racist, a fraud, a hack, and a wannabe, Barstool was merely expressing an opinion, not a nice one, but an opinion, and that opinion could not give rise to a defamation claim. But as to Barstool's claims about Rappaport having herpes or beating an ex-girlfriend or stalking her, the court found those statements to be purportedly factual, that is, provable or disprovable, and as such, those claims potentially could give rise to defamation. But the court's analysis did not end there. The court then considered how objectively reasonable Barstool's statements were. In looking at all of those statements holistically, the judge concluded that they were basically too far-fetched and obnoxious to be believed by reasonable people and found them to be not defamatory. In coming to that conclusion, the court relied on three primary factors. First, that the statements were made in the context of a long-standing and well-known public feud between Rappaport and Barstool Sports, and that the existence of that feud likely gave the audience hearing these insults some clue into the mindset of the people speaking them and whether they might be true or not. The court also found that the fact that the statements were made on social media, and Twitter in particular, diminished the credibility of those statements greatly. The court all but found as a matter of law that you can't believe what you read on Twitter. And finally, the fact that the statements were made by people who make their living as shock jocks also factored into the court's opinion that the audience likely could determine the likely factual nature of the assertions, and Rappaport's defamation claim was dismissed. But what's fascinating to me about this is the perverse incentives this can create. To support his defamation claim, Mr. Rappaport was basically forced to argue that Barstool was a credible news outlet that many fans relied on for truthful information. Meanwhile, the Barstool guys were forced to say, "Judge, come on, look at us. Nobody would believe anything we say." It's an interesting dynamic. Now, what does this have to do with you and your business and the way it communicates online? Defamation law increasingly treats people differently based on who they are and the manner by which they communicate. If a hardworking, mild-mannered business owner like you has a momentary loss of temper and you say something you shouldn't, you might perhaps run a higher risk of being found liable for defamation than does some obnoxious loudmouth who will post anything in order to get a few more followers. Why? Because you're believable and he isn't. Now, is that fair? I'll leave that for you to decide. I'm not suggesting that you become an obnoxious loudmouth so as to insulate yourself from defamation claims, but I am suggesting that you understand this evolving dynamic and that you use it to temper your communications online accordingly. I could go on and on about this fascinating case, but at the risk of losing credibility with my co-presenters, I'm going to pass the floor to another of our litigators, my law partner, Leah Deering.
Thank you, Bill. I am Leah Deering. I handle commercial litigation and have run into all sorts of crazy disputes related to online speech during my career. The Barstool Rappaport dispute is different than most of the cases I encounter for one key reason. Everyone in the dispute owned their statements. In fact, they were proud of the negative, hurtful, mean things they were saying about each other. More often, my clients are dealing with anonymous speech. And while they may suspect who the bad actor is, they cannot necessarily prove it. It may be a negative product review, a negative post about an owner or a location that they believe to be truthful, or maybe even anti-competitive. So what do you do if you encounter online speech that is untruthful or unflattering from an anonymous source? And there are a few options that we can help you with. One is to use the information available to unmask the anonymous speaker. So people's online behavior is often dramatically bolder than their in-person behavior. Unmasking the speaker and dealing with them directly often leads to a dramatic de-escalation of the issues and often a quick resolution. But how do you accomplish this? It is not always simple to figure out who is doing the online talking. Often, a combination of online tools and skilled internet sleuthing can piece together the whodunit. We have a lot of experience in tracking down folks that thought they were being anonymous through trails of evidence they leave associated with their speech. If the speaker has hidden their trail well and the issue is severe enough, you can institute litigation. It can be filed against a John or a Jane Doe, and then subpoenas can be issued to third parties to get information like who is affiliated with a cell phone number or internet IP address or anonymous user ID to help identify the speaker, or at least narrow them down to a specific town or sometimes even a building. But once you identify the speaker, what next? That will depend a lot on who the speaker is and whether they are stating opinions or facts. As Mr. Piercy discussed, there's really no legal remedy for people spewing negative opinions, but you may be able to pursue individuals putting false factual allegations on the internet. On the who issue, my partner Ken Winkler will address when the speaker is an employee. My partner Lauren Frisch will talk about why to avoid your own anonymous post to counter the negative statements. During my time, I want to talk to you about the disgruntled customer or competitor that is speaking about your business on the internet. So there are a few legal and practical ways to address the negative online review. First, a suit if the speech is a false statement of fact. Second, if the goal is simply to minimize the impact of the review on other potential customers that may be evaluating doing business with you, make sure you respond in a polite way that is visible to those customers. Simply acknowledging a complaint and appearing reasonable in response to a complaint goes a long way in curbing any negative impact that the review may have. Third, you can bury the review within some limits by encouraging other satisfied customers to leave truthful reviews, by creating other content that will populate ahead of the negative review on the internet, and by maximizing your SEO, which is search engine optimization. There are firms, some reputable and some not, that will help you navigate these issues. One you can take a look at is reputation.com. They specialize in helping companies with these kinds of problems. But before relying on one of these vendors, I encourage you to reach out to your trusted lawyer at BFE, and we can help you walk through an analysis of which approach is right given your specific circumstance. Briefly, I want to cover two other topics. First, what happens if a third party steals your content and puts it out on the internet? Most often, this is done by internet scammers, posing as you or your company. And it can be virtually impossible to track these folks down. They are professionals at this. Thankfully, there's a simple, inexpensive remedy that targets the website hosts called a DMCA takedown notice. So what is the DMCA? The DMCA is the Digital Millennium Copyright Act. And what is a takedown notice? It is a very simple kind of form letter that goes out to the website host and says, the content on your website is owned by me, and I am the copyright owner, and I'm demanding that you take it down. It's one of the few instances where you can go to an internet provider and demand they take down content. Most internet service providers and web hosts have whole teams that are dedicated to complying with takedown notices because there are consequences if they fail to do so. So if you ever find someone that is using your content on a fake site to confuse your customers or commit a fraud, let us know and we can help you get that material taken down quickly and efficiently. And the last issue I want to cover is domain name squatting, or also known as cyber squatting. So what do you do when someone goes out and buys the domain name associated with your business? This happens one of two ways. A person watches, for example, the Secretary of State filings and sees you register a new business entity, and then goes out and targets domains you may want to use for that business so that you can't buy them yourself. Or it may happen when you accidentally let your domain registration lapse and they scoop it up before you can. The Anti-Cyber Squatting Consumer Protection Act can be effective in many circumstances to regain control over that website. The statute prevents a third party from buying domains that contain trademark names and then profiting by reselling them to the trademark owner. Basically, it's like the website equivalent of an anti-ticket scalping law. However, the law does not prevent a third party from buying the domain and using it themselves. So, for example, there's some pretty prominent disputes that have happened out there. A Canadian company bought kevinspacey.com and tried to use it. Mr. Spacey had a hard time regaining possession or gaining possession of that website because the buyer was national from Canada and not a US citizen. So there was no jurisdiction and no ability to use that statute to force control of it back. Eventually, he was able to do so, but had to jump through a lot more hoops. Tony LaRusso had a fairly prominent dispute with a third party over a Twitter account that was started in his name. This can be a sometimes nuanced issue, but if your business runs into a problem with a third party hijacking its brand through internet domains or unauthorized social media accounts, we may be able to help you regain control. Now, my partner, Ken, is going to talk to you more about the nuanced area of monitoring and attempting to control your employees' online speech.
Thank you, Leah. Thanks for sharing that information. My name is Ken Winkler, and I am an employment lawyer. So I work with our company clients, our employers, and help them with all aspects of the employer-employee relationship and issues and challenges that arise. And certainly this is an area where I've received many calls. So while the Barstool story may be an extreme situation, it really is not uncommon for employees to post comments about their employees online. And typically these comments are not favorable. They might actually be rude, offensive. They might swear, call out people by name. They might call their manager, specific people by name on the web and say bad things about where they work and who they work for. And these situations then typically raise two broad questions that I want to talk about. One is, do employees have a First Amendment right to free speech that protects them with anything they might say on the internet or say publicly? And then the second question is, do employers have the right to terminate employees over these online type of comments? So as the first question, you might be surprised to learn that the First Amendment does not protect employees who work for private employers. The First Amendment protects employees who work for the federal government. But the First Amendment free speech rights do not enter the workplace and protect employee speech in the private employer setting. That's a surprise to many people. So then the next question is, if that speech isn't protected, do employers then have the right to terminate employees for comments that they make online? And that's where it gets a little bit fuzzy, perhaps. So generally, employers do have the right to terminate employees for conduct and speech made online. But there are some notable exceptions to that general rule. First, you always need to be aware of state laws. And while Georgia doesn't have any laws to this effect, there are other states such as California, Colorado, Louisiana, New York, and I believe North Dakota that prohibit employers from terminating employees for lawful conduct outside the workplace. And that could be conversations that take place online. And it can also include political speech. So you can understand in this environment with social justice, reform, et cetera, there's a lot of employees posting opinions online. And in states like California and Colorado, the employer would not be permitted to terminate employees for the comments that they're making politically online. In some other states, maybe that won't be the case. So we always need to be aware of state laws that govern the workplace and how that might impact protections to employees that are voicing opinions or making even derogatory comments online. But in the workplace, we not only have to worry about state laws, but we also have to worry about federal laws. We understand that from the discrimination scheme that governs Georgia. Georgia really doesn't have any laws on discrimination that have much teeth, but employers of a certain size have to be mindful of federal law, such as Title VII of the Civil Rights Act, the Age Discrimination Employment Act, and the Family Medical Leave Act as just some examples. Well, when it comes to employee speech and conduct, especially online, there's a federal law called the National Labor Relations Act. And the NLRA governs all employers, not just unionized workplaces. And there's a special section of the law called Section 7 of the National Labor Relations Act that applies to all employers. And that section provides that employees are protected from engaging in what's called concerted protected activity. That's when employees kind of get together and they complain amongst themselves or talk about their terms and conditions of employment. They might get together and complain about their compensation or that they're working in a hostile work environment. And under the NLRA, if employees get together, even online through chat rooms or Facebook, and they complain about their working conditions, even if the employer doesn't like it, even if it puts the employer in a bad light, the employer is restricted from terminating those employees because they're engaged in concerted protected activity. And that's something that all employers need to be aware of, not just unionized employers. Interestingly enough, every day, attorneys, including all of us at Berman Think, we get legal updates from different developments that are happening every day, court decisions, passage of legislature, all sorts of things. And this morning, in prepping for today's webinar, I saw a news headline on an employment case dealing with this topic. A California-based marketing and advertising consulting firm was held to have violated federal labor law by firing 2 workers after one complained in a Facebook live stream that the company was routinely late in delivering their paychecks. That's what a National Labor Relations Board judge ruled. Again, this is not a unionized workplace, but there you had employees who were not getting paid timely. They got frustrated, went on a Facebook live stream and complained and moaned about how awful it was that they weren't getting compensated. And shortly thereafter, the employer terminated those individuals' employment. They brought a claim, and in ruling in favor of the individuals, the board held that the broadcast is protected despite the fact that its primary audience was the public. It is well established that Section 7 protects employee efforts, in quotes, to improve terms and conditions of employment or otherwise improve their lots as employees through channels outside the immediate employee-employer relationship. So there's just a very recent example of how the National Labor Relations Act has protected employee speech, even in a non-unionized work setting. And that's something that every employer needs to be aware of. So what is a takeaway from today's webinar dealing with employee free speech and whether or not employees are protected, and how do you protect your business reputation by what your employees might be saying? A good starting point is to implement a social media policy. If you don't have a policy implemented, reach out. We're happy to help. You really need to think about implementing that. And then what should your social media policy say, and why do you need one? It's to advise employees up front what is protected, what is not protected, what type of behavior is going to be tolerated, and what type of online behavior is going to cross the line and not be tolerated. So you want to clearly have your policy spell out what type of conduct is prohibited. Typically, the courts have been consistent that any type of harassing or bullying behavior is not protected, and the employer has the right to guard against that and discipline employees for that type of behavior. You might want to have a policy contained within your social media policy that protects your confidential information and trade secrets. Again, the court, including the National Labor Relations Board, has allowed employers to protect the dissemination against the dissemination of their trade secrets and confidential information. So if an employee went online, whether it be on Facebook or some other platform, and was disclosing your company's trade secrets, you as the employer have the right to intervene and discipline the employee to protect your information. And clearly you want your policy to explain the consequences of any violations. So certainly if you're in need of any assistance in this area, whether it be drafting or reviewing a social media policy, please reach out to us. We'd be happy to assist you. I'm now going to turn the topic over, the webinar over to my colleague, Rory O'Sullivan, who's going to talk about how to protect your intellectual property and trademarks.
Thanks, Ken. As Ken mentioned, I'm a corporate attorney here at Berman Fink Van Horn, and in addition to helping clients achieve their transactional goals, as part of my job, I put legal protections in place on the front end to assist our clients avoid liability down the road. And over the last wild year, and as more and more of our clients have expanded their online presence or moved online, I've noticed a marked uptick in the number of questions I've received from our business owners and clients regarding their online activity in conjunction with trademark and copyright law. And so I want to just take a couple of minutes to provide you with a few general tips and do's and don'ts when it comes to managing your IP risk online. And let's start with trademarks. And it probably makes sense to start with a few basics. So I think we all have a general understanding that a trademark is a word, a phrase, a logo, or a design that is used to distinguish the goods and services of one party from those of another party. And as a general rule, an owner of a mark can enforce its rights to prohibit others from using similar marks in connection with similar goods and services. And so if your business has been expanding its online presence or has recently shifted online, suddenly you may have a national audience and potentially national customers. And so there are at least three good starting point questions you should be asking yourself with respect to trademarks. The first is, do I have the right to use my own marks and logos at a national level? A longstanding business that has always operated in one geographic area and that never obtained a federal trademark for its marks and logos, may have certain common law rights to use those marks and logos in the same geographic area, but may be infringing on the rights of others when they expand their footprint online. If you're online and you've never looked into this question, it's likely worth a comprehensive search and analysis to see what other marks exist in the marketplace and what the potential risks and consequences are for continuing to use your own marks. The second question you should ask yourself is, if I do have a registered mark, am I adequately protecting it? And this is something that often surprises people when they hear it, but simply having a registered trademark is not enough to guarantee that your use of the mark is protected against infringers. A trademark is a type of privilege, and to ensure your trademark carries the full range of protections, you should police your mark, and that is, regularly inspect if anyone is infringing on the mark and take action to try and stop that infringement. If you fail to adequately police a mark or take an unreasonably long time in doing so, you may lose your right to object to that infringement and may lose the right to expand your trademark to cover other goods and services in the future. And the third question you should ask yourself is the way I'm promoting and marketing my goods and services online infringing on anyone else's trademarks? And to go back briefly to the story that Bill introduced, Barstool began selling t-shirts featuring Mr. Rappaport. Now, let's imagine for a minute that in promoting and marketing this shirt online, they used photos of various stadiums that had legally purchased the rights to from Shutterstock. And a number of these photos contained in the background the logos of professional sports teams. Now, by using these images, Barstool is likely infringing on those sports teams' trademarks, even though they had a license to use the photo, and even though the use of the logo seems incidental. Takeaway, I mean, there are only a limited number of scenarios where someone is allowed to use the trademarks of others, including, for example, if you must use a trademark to describe your own goods and services, or if you're reporting the news, or if you're engaging in comparative advertising. This Barstool example doesn't fit into any fair use. And more importantly, Barstool is using the logos in a commercial context that may convey the impression that the sports teams were affiliated with Barstool or were endorsing Barstool's shirt, which is a big trademark no-no. And this is an issue I've seen come up repeatedly over the last year, with new websites and a lot of new online content. And so if anyone is unsure of whether their content contains infringing material, we'd be happy to review it and provide our analysis. And using stock images on your website, like Barstool Sports in my example, also carries certain copyright implications. And briefly, a copyright protects original works of authorship, including photos and images. And if you're using images on your website, which you probably are, you need to be sure you have the right to use those images or that you own the images. And in general, I've seen people do one of three things. The first is they take the images from Google or another public search domain. Don't do this. This is a recipe for disaster. You almost certainly do not have any right to use those images. And if you do use them, it would be reasonable to expect a cease and desist and potentially even a claim for damages. The second way is to license stock images from a repository. But be aware, and this is something that a lot of people don't realize, if you acquire a license to use an image from one of the big repositories like Shutterstock, for example, you may not be purchasing a license to use the image commercially. Some images can only be licensed for non-commercial use, and so you have to check to make sure. The third way is to create the images yourself, which understandably may not be practical in every scenario, but if you do go this route, you should be aware that if you hired any third party who is not an employee to help create those images, that third party may have an ownership right in those images if there's not an agreement with specific language in place that clearly establishes your ownership. And this concept expands beyond images for your website too. I mean, this would apply to any design or creative works that you hire a contractor to perform, or that any employee performs for you outside of the scope of their employment. And before I hand it off, just to summarize, you should take some time to inspect whether your trademarks and copyrights are protected, or whether your online presence is violating any other person's trademarks or copyrights. And if you have any questions, we'd be happy to jump in and help address your concerns. I'm going to turn it over now to Lauren Frisch. Lauren is a litigator in our office, and one of her focuses is in assisting companies in the area of deceptive trade practices.
Thanks, Rory. Good afternoon. As Rory said, my name is Lauren Frisch. In addition to several other areas of business litigation, one area I do focus in is on deceptive trade practices. Now, I'd be surprised if any of the viewers of this call have really given much thought to whether their company is in compliance with the laws related to deceptive trade practices. However, having worked in this area, having guided clients in this area, I did want to bring it to your attention because, there really are consequences if a company is not cognizant of what they're doing. The term deceptive, especially in deceptive trade practices, gives off this image of a company that doesn't care about its customers, of a company that's a bad guy. But more often than not, the companies that run afoul of the deceptive trade practices rules are really companies that are just ignorant of the requirements, what kind of disclosure should be on their website, or really just don't have an understanding of their obligations under these laws. So I did want to bring it to your attention. You could be the subject of a Federal Trade Commission investigation if you run afoul of these rules. The state also has a special office within the Attorney General's office that looks into these matters. So just a few things for us to go over today as we think about companies that are pivoting towards an online presence. I wanted to talk about the mail order sales rule. Now, this is a rule that was issued by the Federal Trade Commission, and as the name states, it applies to mail orders, but it also has been expanded to apply to internet orders. So if you're a company that is selling an item online for delivery to a consumer, this is a rule that will affect you. So let's turn back to that Rappaport example. With the Rappaport case, shirts were developed that depicted Mr. Rappaport as a clown having a mark beneath his chin. Let's say these shirts were wildly popular, took off thousands and thousands of orders, many more orders than ever anticipated, such that the company didn't have enough shirts to send to customers at the time all those orders came in. Well, at a very high level under the mail order sales rule, a company is obligated to deliver merchandise within the time that's been specified. So if the website had said, for delivery within 7 to 10 business days, or if there's no time specified on the company's website, the obligation is to get it to the consumer within 30 days. Now, what happens when you get into that spot that Barstool could have been in, where you cannot deliver items to the consumer? And this could be because you underestimated how popular the item would be. Or, in this era of COVID, we can all imagine a scenario where the supply chain simply breaks down, or there's an issue with UPS or FedEx or any of the carriers that leads to issues with timing of delivery. So this rule is all about communication. If a company cannot comply with their obligation to deliver items within the time specified, they need to communicate with the consumer about the delay, the estimated new arrival date, and give the option to cancel. And there's really a series of steps that kind of can be taken from there to comply with the rule. So if you are in this spot, if you sell items online and have concerns about whether you are in compliance with the mail order sales rule, please feel free to reach out to me and I would be happy to discuss any specific questions with you. Additionally, the FTC also has a guide for businesses on this topic. So if you just want to look into it at a high level, that is an excellent place for you to start. I now want to turn to another topic that's important as we think about deceptive trade practices and internet businesses that operate online. So Leah had touched on what happens when you get a negative review from a consumer and what steps you can take to appropriately address those complaints, to potentially make yourself look better. And what I'd like to talk about is really the other side of the coin, which is the temptation post a positive review for your company that either comes from someone internally, the family member who's never used your services, somebody with a fake account on Yelp, other than the fact that you made it up to them. And while it's tempting to post these reviews, it really seems like a victimless crime. The problem with it is that if an organization like the Federal Trade Commission or the Georgia's Office of Consumer Protection and the AG's office looks at it, that they're going to view it as a violation of their laws, the Federal Trade Commissions Act, the Fair Business Practices Act. And at $2,000 per violation under the state law, and a different violation for each day that review is posted, suddenly your one review becomes a very costly scenario. So while it appears to be tempting, like Leah had counseled, really the better option is to encourage your legitimate customers to post honest reviews about the services they've received. And encouraging those with the customers you have a good relationship with increases the chances that that review will be extremely positive. Now, the last topic I'd like to touch on involves representations involving geographic origins. As companies transition to being more so online than having an office or brick and mortar location, they really come up against the conflicting idea that it's positive to have an association with a specific city. So you're online, it's great, you're now reaching a national platform as opposed to the foot traffic in Marietta Square. But at the same time, how do you maintain that reputation as, for example, a local Marietta business? Now, if you try to insinuate, for example, that by having a post office box at a FedEx store in Marietta, you have somehow maintained your connection to that location, it is likely that you could run into issues. You have to be very careful about the phrasing. We are a family based out of Marietta. We've been running our business for X number of years. There are ways to go about it that are both truthful, not deceptive, and will be a marketing positive for your business. So if you have questions about this area as well, kind of how can you position your website? How can you use the fact that maybe you're now mobile to be a positive thing for your business, or the fact that you're not wasting the overhead on office space? We can talk through those strategies as well. So just to summarize things, don't forget about the deceptive trade practices obligations that are out there. And if you need assistance reviewing your website, reviewing notices, talking about actions that you can take with your customers to make sure that they completely understand the nature of your business, please reach out to me either by phone or by email, and I'd be happy to help you. So with that, I will turn things back over to my colleague, Ken Winkler.
Thank you, Lauren. And I think everyone that's listening can appreciate the complexities that exist with your online presence and all the different areas of the law that can get triggered when you are active online and visible that way. We've just got a couple minutes to field some questions. One that came in was an interesting one, and the question said, for states that prohibit termination of employment based on social media activity conducted outside the work environment, is it possible to override the state requirements in the employment offer letter of employment? In other words, can you basically contract away someone's rights to off-duty conduct in these states that have these laws? Without looking at the particular state, I couldn't answer that with certainty, but typically when you have something on the books, a law, a statute, as a matter of public policy, you cannot waive voluntarily your rights under those statutes. Certainly at the federal level, a party is not allowed to waive the rights to any protections under the National Labor Relations Act. So probably not likely to alter or remove someone's rights by contractual agreement, even though courts like to enforce contracts in that area. I think the employees' protections are probably going to withstand and survive any attempt to waive them by contract. We've also received a number of questions about the pandemic, a little bit off topic, but it's so important, I think I'll address it. And the number one question that we've been asked repeatedly is, do private employers have the right to mandate vaccination as a condition of employment? And the answer is that private employers do currently have the right to require vaccination for their employees. Again, there's always some caveats, so there's some exceptions. And the two notable exceptions are if someone has a medical necessity, a medical exemption, a need not to take the vaccine, and that is recognized by the Equal Employment Opportunity Commission. And also if someone has a religious-based belief, a faith-based belief not to get vaccinated, that's also a recognized exception. And then there's different rules that are going to apply to what happens if someone raises one of those exceptions. I'll let you know that the EEOC has published some material on it. The head of the EEOC has indicated that because of this import of this topic and because of all the questions and inquiries they're getting, keep a lookout for some new guidance, some further explanation from the EEOC about an employer's rights to require vaccination, things dealing with incentives, all the different issues that you might be reading about regarding the issue of whether or not employers can require vaccination and what do they do in circumstances when employees are reluctant to get vaccinated. We're certainly going to keep up on this topic and continue to post blogs and updates and issue those out when new developments happen. With that, I want to, if no one else has any further questions, I wanted to wrap up today's webinar and thank everyone for their participation and interest in this topic. And I would just like to end with just a tip. We have a new president, been in 100 days approaching, and there's been a lot of change already, certainly in the employment arena. And I anticipate that there's going to be a lot of changes going forward. And in particular, the topic I talked about today, dealing with protected speech, there's been a lot of discussion that I've been reading about at the federal level of increasing employees' protections, certainly in the union setting. So that's something to really, again, pay attention to, look for updates, reach out for any question, with any questions you might have. Over the next 4 years, I think we're going to see a lot of developing changes in the workplace, and that can have a direct impact on how you operate your business every day. So just would like to wrap up the webinar. Thanks so much for your participation, and we look forward to seeing you again soon during our next webinar. Take care.